What do you do when you have a client come in that's got all these, crazy interstate issues and all these crazy international issues? The first thing that you want to do when you want to talk to them about is sort of getting the timeline. The timeline is hugely important when you're dealing with interstate and international issues. Getting an exact timeline from your client, knowing exactly when they moved, exactly when the other parent moved with the child, and knowing how fast you're going to sort of have to act and get things filed, whether your deadlines are passed and you're just kind of out of luck or the other side is out of luck. Knowing all of those things is hugely important, and getting as precise a timeline as you possibly can. I mean, I have clients that'll come in and they'll go, well, it was about, 5 or 6 months ago. Well, that's not really helpful. 5 months, 6 months, 7 months, huge difference in there when it comes to the law. So it's really, really super important that you get as precise of a timeline as you possibly can. Have the client prepare what I call a history, a client history, custody history, case history, do basically a chronological narrative and providing all of the documents relating to that. It's matter of fact, we actually have a client questionnaire that we send out, like a custody questionnaire that one of our attorneys in the Fort Worth office helped us with, and it's great. It's like a 10, 12-page document. I don't know, it's really long, and it goes through basically everything that you can think about and specific questions on everything relating to what could possibly be an issue for a client in a custody or child support case. So, devising something like that, or if not, if you don't want to take the time to kind of go through all of that and do a long questionnaire, for your clients that's sort of tailored to what you need and what you like, go through and just have them do a precise chronological history of your case. And kind of my explanation I always use is, I always say, I have to teach your case to the judge, and I have to teach your life to the judge. And, I haven't been there for the last 10 years, so I need a history from you that's written, that's in your own words, that I can look at, and that will assist me in teaching your case to the judge in an hour. If there have been hearings resulting in orders from other states, that's another major thing to look at. Get copies of everything before you sort of proceed in filing a bunch of things and, or taking a bunch of action and advising the client as to what you think. When you have a bunch of orders out there floating around that you don't have copies of, if the client doesn't have copies, let them know. They've got to get copies, or they've got to let you go ahead and get the copies before you can really do anything, before you can even really research the case. There's so many times, and I'm sure you guys have all had that experience, where the client comes in with a petition and goes, well, yeah, I think this is my order, or they go, well, I know that there's something out there floating around. I know there's some kind of order, but I'm not really sure what it is, and I don't know when it was, and they don't have copies, and that was 10 years ago. So, all of those things, making sure you're getting copies of everything that's out there is obviously hugely important, because, with child custody issues, if you're looking at interstate issues, you've got that whole continuing exclusive jurisdiction issue, where, if a court has continuing exclusive jurisdiction because they issued a prior order, you may very well not be able to do anything in your state. So you might have to turn the client away and say, hey, you're going to have to go get an attorney in Colorado or wherever they're from. So, making sure that you know everything that's going on before you even get to that point is important. Finding out your client's specific goals. I always, along with the history, I have them do sort of a list of goals, and we sit there and we discuss the goals and we write them out. And so we have an idea of, this is what we ultimately want. And then as we kind of progress through the case, I sort of do a best case, worst case, most likely case scenario after going through and researching everything and kind of saying, well, here's, based on this and based on cost, based on expense, based on jurisdictional issues, all of these things, are any of these goals something that you want to revise now that you have all of this information? So making sure you're very clear on that and what you can do for the client. Please remember, USIA and UCCJEA are really complicated, and as much as I look at them and as much as I study them, it's still, you can still very easily make mistakes if you aren't referring to this information. So making sure that you're going through, highlighting everything that's important in your case, and that you have information on that. Another important thing is making sure your clients know that, making sure that they know that this isn't just something that, this is an area of law that we probably don't deal with every single day. So it's not something that we should be rattling off the top of our heads, and advising them, making sure that they know that even if you are giving them advice, that the more facts and the more you understand and the more information you find could change your outlook and what you're going to say about the case. Okay, International Child Abduction and the Hague Convention. So when do you have a client come in, and when should you can be concerned about this to where, you have a client come in and they may have a risk of foreign abduction? Really, any client that has the risk of taking a child abroad, especially if you have a client that has dual, or the opposing side has dual citizenship, that is a really, really dangerous area to be extremely watchful on. If they have family in other countries. So being sure you're asking these questions when you get an initial or when you have the client come in for the first time to meet with them about the issues of the case. Do they have family? Does the other side have family abroad? Is international abduction any risk whatsoever? And be sure you're advising them. A lot of people don't think that their spouse is capable of doing something like that, and they don't think they're capable until they do it, and then the kid's gone. And then they don't see their kid for 10 years. So, making sure that you're kind of anticipating that this is going to be an issue. And some of this isn't really hard to get the judge to grant sort of safeguards to put in place to prevent child abduction. So what is the Hague Convention? Effectuates the return of children wrongfully removed or retained across international borders. Hague countries were required to return under certain circumstances, but they're discretionary in other. So just because somebody's a Hague Convention member and your opposing party took off with a kid to that country does not necessarily mean that return is going to be mandatory. That's why this stuff is complicated. And even under Hague Convention, sometimes it's difficult to get kids back. How do you seek relief under the Hague? Once again, that central authority. You contact the central authority of the country where the party resides or the country where the child is located. So if you've got someone who took off and took the kid to Italy, you contact the central authority in Italy. Once again, it's sort of the equivalent of the U.S. State Department here. Now, the case will not be heard by the central authority. The central authority basically just starts the proceedings to get the case heard by the court with jurisdiction to hear family law matters. The central authority only begins the process. So be sure that you're monitoring that process if you're working with another attorney in a foreign country or you're trying to work with your client in a foreign country to get this stuff done. Be sure that you realize that it's just the central authority gets the process started, not who actually ends up hearing the case. It's going to be the family court in that jurisdiction that will hear whether or not it's a mandatory discretionary return and whether or not the child should be returned under the Hague Convention. Mandatory versus discretionary return. Mandatory, if there's going to be a mandatory return, the party must show the requesting country is a country of habitual residence of the child. Less than 1 year has elapsed from time of removal to time of commencement of proceeding in country from which you're requesting return. And removal of or retention of the child was wrongful. So you have to show that it's a habitual residence, less than 1 year, and the removal was wrongful, by showing the removal or retention is a breach of rights of custody under the law of the state where the child habitually resides. So it's basically breaching a custody order here, or some kind of a custody law here. At the time of removal or retention, those rights were actually exercised or would have been exercised but for removal of retention. So if you have a custody order in this state that even has standard possession, prevents someone from, and the international child abduction prevents those rights, or somebody who has legal custody of a child and that prevents those rights, and you meet those other two requirements, then that would fall under mandatory return for Hague. And this talks about discretionary return. Discretionary return is if more than 1 year has lapsed since the removal when at time of filing. If the child is well settled in their new environment, they've been over a year. Return would pose grave risk to the child or parent. You need clear and convincing evidence of grave risk. This probably would be most occur in family violence issues where somebody's sought asylum in another country, taken the child to another country due to family violence issues. The child is 16 years of age or older, or the child is of sufficient age and maturity and expresses an objection to being returned. So if you have a 16, 17-year-old, or you even have like a 14, 13, 14-year-old, and the child doesn't want to come back to the United States, discretionary return. So those are all things that the court can consider with discretionary return. That's a lot. I mean, that applies to a lot of kiddos. So really being sure that you know whether or not you're doing mandatory or discretionary is important.